right, so into presentation mode. All right, so our presentation today is the Business Professional's Guide to Connecticut Paid Leave. So we're going to run through some information about the Connecticut Paid Leave Program. We're going to talk about the Family and Medical Leave Act and how it differs from the Connecticut Paid Leave Act, implementing Connecticut Paid Leave, coordinating Connecticut paid leave benefits with employer-provided benefits that you may have for your employees, implementing Connecticut Family and Medical Leave, and we will leave you with some additional resources. If you have any questions as we're going through, please feel free to put them in the Q&A feature at the bottom of the screen, and we will answer them for you. So just a quick overview, the Connecticut Paid Leave Authority is the entity that oversees the program. We are a quasi-public agency. And we have 5 key responsibilities, which include outreach and engagement, developing the policies and procedures needed to run the program, establishing the trust fund contribution rate and receiving the contributions, auditing and approving private plans for folks who would like to have their own plan as opposed to participating in the public plan, and administering claims for benefits. To take you back in time a bit and kind of look at the timeline that got us to where we are today. In November of 2020, we opened up employer registration. Starting in January 1st of 2021, according to the law, employers were to begin deducting 0.5% from worker paychecks for contributions to this program. It is 100% employee funded. So all of the funds that are ultimately used to pay benefits do come from these employee contributions. In February, we began accepting applications for private plans. Our agency accepts payments quarterly. We ask that you, as the employer, remit them quarterly to us. There is a 30-day grace period after the end of the quarter. So for example, first quarter, January, February, March payments are due by April 30th, and so on and so forth. In December, we opened up our online application portal. We began accepting applications for folks who were anticipating needing paid leave benefits for qualifying reasons. And starting just a few weeks ago, on January 1st, we began issuing payments for those qualifying circumstances. So who is covered by this program? Employers in the state of Connecticut who have 1 or more employees do have to participate in this program by statute. That does include nonprofits and private sector employers with a unionized workforce. Now, sole proprietors and self-employed individuals may choose to opt into the program if they would like to. They are not required by law to do so. But if they do opt in, they would contribute the same amount as any other employee, so half of 1% of their earnings. And they do have to remain in the program for a minimum of 3 years if they choose to opt in. There are some exclusions, which you'll see over on the right side of the slide. So employees of the federal government are excluded from the program. State of Connecticut employees, except as to covered public employees, are excluded. Employees of municipalities and local or regional boards of ed are also excluded unless they have covered public employees, which I will explain what that means in just a moment, and non-public elementary or secondary schools. And then there are also, as you can see further down on the slide, some other exemptions, and these folks are not covered because there are other laws that provide similar coverage for them. Now, I mentioned a few circumstances where covered public employees came into play. So what does that mean? Covered public employees means non-unionized employees of the state of Connecticut, so they are covered by the paid leave program. Unionized employees of the state of Connecticut who collectively bargain to be included. So if their union collectively bargains to pay into and be covered by the paid leave program, then those employees would be covered. Employees of municipalities and local or regional boards of education. If the unionized employees collectively bargain to be included in the paid leave program, then all employees, both union and non-union, would be covered. Now, I mentioned that employers take a contribution of 0.5% of wages from employee paychecks. Those contributions are post-tax and they are based on the wages as calculated for FICA. And the contributions are capped at the Social Security limit, which has just gone up to $147,000. So that means that regardless of what someone makes over $147,000, they would never contribute more than the maximum, which works out to be $735 per year. Once the employer remits the contributions to us, we receive them and we validate that the correct amount has been sent to us using data we have from other state agencies. We then deposit those contributions into the Paid Leave Trust Fund, and the Paid Leave Trust Fund is the source of funding from which benefits are paid out. Now let's review FMLA and Connecticut Paid Leave. These are two different laws, and they provide different kinds of protections or benefits. So FMLA is the Family and Medical Leave Act. There's both a federal FMLA and a state FMLA, and these have been around since the 1990s. So these are not anything new. However, there have been some significant changes to the Connecticut law, which we'll talk about. The basis of both laws is that they provide job protection for someone who needs to take time away from work for certain family or health reasons, but that leave is not paid. So while some employers do choose to pay employees while they're on leave, so for example, maternity leave or a medical leave, they don't have to. That is not a requirement. The requirement is that someone who has this family and medical leave protection is returned to their same job, meaning the same position, salary, schedule, etc., when they return from their leave. Now, Connecticut Family and Medical Leave has just undergone some pretty substantial changes, which went into effect on January 1st. And so this chart shows a side-by-side comparison of what FMLA was last year and prior and what it looks like now. One of the biggest changes is that before January 1st, if you had a business with less than 75 employees, you did not have to adhere to the Family and Medical Leave Act. Now employers with one or more employees do have to consider if someone is eligible for job protection under FMLA if they are taking leave. A second change is that previously there was an hours worked requirement and a length of time that someone had to work in order to be eligible for job protection. That hours worked requirement has now gone away, and the length of time for job protection has been reduced from 12 months to 3 months. So after 3 months, with no minimum hours worked requirement, a person going out on leave for a qualified reason would be entitled to job protection. Next, the length of time has changed. It used to be 16 weeks of leave in a 24-month period, and that has changed to 12 weeks of leave in a 12-month period for almost all leave reasons. There previously was, and there still is, a special length of time for military caregiver leave, which is 26 weeks. Additionally, new part of the law is that an additional 2 weeks of leave are potentially available for someone experiencing incapacitation during pregnancy. And then the last change to be aware of is that previously an employer could require their employee to use all of their accrued paid time off if they wanted to be paid while they were out on leave. Now the employer must allow the employee to retain up to 2 weeks of accrued PTO if the employee would like to do that. So for example, if someone is going out on leave to have a surgery, their doctor tells them that they'll need to be out for 4 weeks and they have 4 weeks of PTO saved up. The employer can require them to use 2 of those 4 weeks, but has to allow them to save the extra 2 weeks for future use if they would like to. If the employee decides that they want to use that time, then that's fine. But the point of it is that the employer cannot require them to use all of that time. So Connecticut Paid Leave, you'll often see the acronym CTPL, and we use that to refer to the law, the statute itself, the program, and ourselves here at the agency. Connecticut Paid Leave creates a source of income replacement for folks who are taking time off for these eligible family and medical reasons. But on the flip side of family and medical leave, which provides job protection, Connecticut Paid Leave does not provide job protection. It provides income replacement, but it does not provide the ability to get your same job back after your leave. And so what that means is that it is possible for someone to be eligible for income replacement through Connecticut Paid Leave, but not be eligible for job protection under Connecticut Family and Medical Leave. Here are the reasons that someone can apply for family and medical leave and or receive benefits under Connecticut Paid Leave. The first is medical leave, which is someone taking leave to care for or receive treatment for their own serious health condition. That does include serving as an organ or bone marrow donor, and pregnancy is also considered a serious health condition. We've been getting a lot of questions about COVID, not surprisingly, so just wanted to add in here that simply being exposed to or diagnosed with COVID is not in and of itself considered a serious health condition. There are specific criteria for a serious health condition. However, if someone did develop other complications from COVID and their medical professional provided the required documentation showing that their condition met serious health condition definition, then they could potentially be eligible for benefits. The second leave is bonding leave. That's leave that parents take to bond with a new child that has entered their home, and that child could have entered the home through birth, adoption, or foster care. Both mothers and fathers may take bonding leave, and it is available at any time within the 12 months immediately following the child's birth or placement in the home. And in the case of adoption or foster care, this kind of leave can also be used to attend to pre-placement activities. Caregiver leave is the third type of leave. This is leave that someone takes to provide psychological or physical care or comfort to a family member who's experiencing a serious health condition. Connecticut has a special provision for family violence leave. So family violence leave can be taken by an employee who is a victim of family violence for reasons like obtaining services from a victim service organization, attending court proceedings, seeking medical attention, etc. And up to 12 days in a calendar year can be used for family violence leave. That is not in addition to the 12 weeks. That means that of the 12 weeks of leave that someone could potentially be entitled to for all of these reasons, up to 12 days of that leave can be used for family violence. And then we have two types of leave that apply to the military. One is qualifying exigency leave, which is leave an employee can take if they're notified that their spouse, child, or parent has been called to active duty. And there's also military caregiver leave, which is leave to care for a family member who's been injured in the military in active duty. Now with caregiver leave, these are the familial relationships that are outlined in the statute that someone can take caregiver leave for. So you can see the listing of them there. But there's also a provision that says an individual related to the employee by blood or affinity can also be considered a family member. So what that means is if you have a close relationship with someone that is essentially like one of the relationships outlined in the statute, even if there's not a biological or legal relationship between you and that person, you can take caregiver leave to provide care for them. So what are a couple of examples of what this might look like? It could be an aunt or uncle who relies on the employee for unpaid care, and they have a relationship like that you would normally see between a parent and child. Another example would be an unmarried significant other of an employee with whom the employee maintains a home. Perhaps they have children, they share finances, but they're not legally married. So therefore, they would be considered related by affinity. Let's take a look at the eligibility requirements for three different types of laws. There's federal FMLA, which is not changing, but we put this here just for context. Then in the middle, Connecticut FMLA, and over on the right, Connecticut paid leave. So federal FMLA continues to and has always applied to employers with 50 or more employees. And someone is eligible for job protection after 12 months of employment and at least 1,250 hours of work. As we said, with Connecticut FMLA, as of just a few weeks ago, the job protection kicks in at 3 months with no hours worked requirement. To be eligible for Connecticut paid leave, there are a slightly different set of requirements. So, excuse me, sorry, I didn't mean to advance the slide. So one is the minimum earning of at least $23.25 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. That can be from more than one employer. So if there's a part-time employee that works 2 or 3 jobs, as long as their total earnings between all of those jobs adds up to $23.25 in that base period, they would meet that requirement. And then they must either be currently employed or had been employed during the 12 weeks immediately preceding their leave. For sole proprietors and self-employed individuals, they must, of course, have opted into the plan. And there is a residency requirement for sole proprietors. This does not apply to typical employees, but sole proprietors do have to be residents of Connecticut. Now, how much time or what length of benefits can folks receive under these three laws? Federal FMLA provides up to 12 weeks in a 12-month period for all reasons, with the exception of military caregiver leave, which provides up to 26 weeks in a 12-month period. Connecticut FMLA now mirrors that, with the only differences being that Connecticut does again have that special provision for family violence leave with up to 12 days in a calendar year, and the additional 2 weeks potentially for incapacitation during pregnancy. Connecticut paid leave will provide up to 12 weeks of income replacement for all reasons, including military caregiver leave. So if someone is taking military caregiver leave, they could potentially be eligible for 26 weeks of job protection, but only 12 of those weeks would be eligible for income replacement. Again, we do provide up to 12 days of income replacement for family violence, and we do provide that additional 2 weeks for incapacitation during pregnancy. Now, there are a few other laws to be aware of that provide job protected leave. So we've talked about federal FMLA, Connecticut FMLA. There's also workers' compensation for covered on the job illness or injury. And then there are laws such as the Americans with Disabilities Act, which applies to 15 or more employees, Pregnancy Disabilities Act, and Connecticut Fair Employment Practices Act. And those laws state that leave may be a reasonable accommodation that needs to be provided to the employee. The only laws that provide income replacement are Connecticut paid leave and workers' compensation. So I'm going to turn it over to Kathy to talk about the implementation of the Connecticut Paid Leave Act. Oh, I see Kathy. I was going to say we just got a question. I see Kathy's typing the answer. So we will let Kathy finish typing that answer, and I will turn it over to her to talk about the implementation of these laws.
Okay. Thank you, Jessica, for that. I was just in the middle of the sentence, and when I heard you say you're going to turn it over, I lost my train of thought. I was like, what? So good morning, everyone. My name is Kathy Mihailuk, and I'll be going over through some of the steps that various people during the Connecticut paid leave claims process will take. And what we're going to do is start with the worker or the employee. Most importantly, the worker needs to submit the application in a timely manner. And they would do that by going to the Connecticut paid leave site, create a Connecticut paid leave account. Once they set up the account, another button will pop up asking them, will they be, excuse me, will they be filing a claim? And that portal is from Aflac, who is our TPA for claims administration. So it's actually a two-step process. They need to set up an account on Connecticut paid leave. And then if they have all their documentation ready and they're ready to file the claim, they could go right into the Aflac portal and then file their claim information. As a result of that process, the employer will receive from the employee what's called an employment verification form. And what that does is that verifies an employee's hours, their regular hours, any overtime, their average hours for the 12 weeks prior to going out on leave. It also asks questions about PTO policies, also about short-term disability policies. Some companies start paying short-term disability after 5 days. Others pay it after 10 days. So in order for an employee not to receive more than 100% of their regular pay, we ask these questions as a coordination of benefits between Connecticut paid leave and the employer. So once Connecticut Paid Leave Authority and or Aflac receive this information, they determine the eligibility of the employee, review the supporting documents, and either approve or deny the claim as appropriate. Calculate and pay benefits, monitor the ongoing claim. For example, Sometimes people are on intermittent leaves and they say, okay, I need to do this for 8 weeks. And then after a while, you find out, okay, they went to their doctor and they only need 4 weeks of intermittent leave. So basically, when we monitor ongoing claims, it's to monitor, have there been any changes? Have there, is the leave extended? Perhaps the employee requested 12 weeks, now they need 5, or vice versa, whatever the situation may be. We also assess requests for reconsideration. Let me explain what reconsideration means. Reconsideration is the employee's opportunity to, if the employee has received a claim, they've submitted a claim and then it was denied, then they have an option for reconsideration. A reconsideration form will be posted on the employee's account with Aflac. What that is there might be missing information. It might be a timing issue with the doctor, perhaps with the healthcare provider. Perhaps the paperwork wasn't submitted on time. So we're giving people another opportunity to, reprocess their claim if they feel, oh my goodness, it should not have been denied. It was my fault. I submitted this late. So that's what the consideration process is all about. Connecticut Paid Leave Authority and Aflac also investigate potential fraud. And we'll find out as we go through the slides that, for instance, if someone's on unemployment, they cannot apply for Connecticut Paid Leave. And penalties are imposed as appropriate because there will be fines. If we find that there's some fraud and there's been double dipping, there's a whole separate process that Connecticut Paid Leave Authority has for that. The Connecticut Department of Labor, there's an appeals process. Let's say a claim was reconsidered and it's still denied. A person can go through an appeals process through the Connecticut DOL with forms on their website to appeal the denial of the claim and to potentially, disagree with any penalties. Thank you, Jessica. So the income replacement benefits process. Worker uses the online portal to submit their claim. They have to create an account with Connecticut Paid Leave first. If they do not, and let's say an employee goes right to the Aflac portal, they will receive an error message. And we receive these through our contact center, and everybody thinks it's an IT issue. The system's not working. No, it's because the employee needs to go in, set up an account, and then process the claim through Aflac. What's happening is the system knows it's reading that a step was missed in the process. So the employee or the worker submits the application checklist, supporting documentation, reason for the leave, how long they're going to be out, the type of leave, if it's illness or caregiver leave or bonding leave, whatever type of leave it is. And then other jobs, sometimes people have 2 jobs, they might have 2 part-time jobs, and other sources of income. Aflac determines the eligibility by reviewing all this information, all the provided documentation, and also they look up Department of Labor data. Aflac validates that the worker is working for a covered employee or is a registered sole proprietor. If it is determined that the worker is not eligible, again, Aflac would notify the worker and offer the request to reconsideration. Aflac determines if the claim is approved. Aflac reviews the documentation, including the employment verification form. Aflac notifies worker if the documentation is missing. If the claim is denied, Aflac notifies the worker and again offers the request, the right to request reconsideration. Something to keep in mind for all employers: once the worker gives the employer the employment verification form, you as the employer have 10 days to get that form back to Aflac. Normally, a person would submit a claim 30 days prior to when they're going out on their leave. Sometimes the process goes very quickly because they have the documentation and perhaps the eligibility is determined quickly, say within 10 days. But if there's documentation missing and say the healthcare provider is, I don't know, out of the office, it may take up to the 30 days to get all the documentation together. So Aflac calculates the benefits by using the Department of Labor data, meaning salary, and other sources of information to calculate the base weekly earnings. Aflac calculates the weekly benefits, taking into consideration the type of leave and offsets for other income. That would be, for instance, PTO. Let's say you have a policy, the first week anyone goes out, they have to be paid PTO. If that's your company policy, you pay PTO the first week, and then Connecticut paid leave would start immediately after that. Aflac issues benefit payments. Aflac offers employees direct deposit or what's called a stored value card, or it's a Visa debit card. Benefits are issued every Tuesday, which means payments are made every Tuesday, and they're made 2 weeks in arrears. So for example, someone's approved, someone's out on benefits from January 2nd to the 8th, they will receive their first check on the 18th. The worker notifies Aflac of any changes. That includes start date. Perhaps there was a change in the start date. They postponed surgery. Maybe they don't need as much time. Maybe the worker was on a reduced schedule. Now they're like, I'm going to take intermittent leave. So any one of those changes in the type that affects the leave and the time being taken, the worker has to notify Aflac, because there might be additional information Aflac needs from the healthcare provider to back up the changes requested. Okay, here is an example of what we call the employment verification form. So the top portion of the form, the employee completes: name, address, social, case number. For the most part, we see employees not completing the case number information. Please note that once they go to the Aflac site and they process their claim, the case number is in the Aflac portal. So I think either sometimes people just forget to put it in, or they don't realize that that information is on the site. The employee signs the form, hands it to the employer, and there's a note, instructions to the employer: please complete the following information and return to Aflac within 10 calendar days. Just to let you know, on the form, I don't see it here, there is a fax number and an email address for the employer to send in the form. Now, we are in the process of making some changes to this form. So just to highlight, FEIN, tax ID number, and the SIC code. Technically, we only need the FEIN number. So in a version of a form that we're working on for April 1st, you're only going to see the FEIN number. We're taking those other two sections off. We need a contact name, a contact phone number, and an email address at the employer, just in case we need to verify or have some questions about short-term disability start date, PTO, or any other backup information we might need from the employer. So benefit calculations. Minimum wage workers receive 95% of their base weekly earnings. Those earnings, people who make above minimum wage have a slightly different benefit calculation. So for example, maximum weekly benefit is capped at 60 times the state minimum wage. So 60 times $13, which is the current minimum wage rate, is $780. That is the maximum weekly benefit a person could receive under Connecticut paid leave. Please keep in mind what we try to do through the employer verification form and all the documentation is to ensure that a worker does not receive more than 100% of their normal pay. So here's an example. We have what's called a benefits estimator on the Connecticut paid leave site. And I encourage everyone to go to the ConnecticutPaidLeave.org site, take a look around, look at the information. There's a lot of webinars, there's copies of forms, there's a lot of information on that site, which is very valuable to employers. So here on the benefits estimator, you can put in weekly, quarterly, annual amount. Please enter your gross earnings. So I'm just saying, if you wanted to do this for an employee to get an estimated amount as to what their CTPL benefits may be, you put in their gross earnings, boom, hit the button, estimate. The benefit estimate shows on the left lower side of the screen. And this is how it looks online also. Okay, coordinating Connecticut paid leave benefits and employer-provided PTO. So now we have a couple different scenarios to help you go through the process as an employer in administering the Connecticut paid leave program. Scenario number one, let's say a worker has no PTO to use. If the worker has no PTO, then day one, they're going to receive the full amount of Connecticut paid leave. Scenario number two, let's say a worker has enough PTO to cover the entire leave. Excuse me. We have had conversations with some employers where they offer 12 weeks of absence management coverage. In other words, they have special paternal programs. Someone goes out on leave, they pay the full 12 weeks. So if that's the case, and you're one of those employers that has one of those programs, you would not be getting, that employee would not be getting any Connecticut paid leave benefits because they're already getting paid 100%. Scenario number three, the worker has PTO to cover part of their leave. So let's say someone starts their leave, February 1st, they're out for 8 weeks. So 4 weeks is covered by PTO, and then the other 4 weeks would be covered by Connecticut paid leave. Scenario number four, PTO is less than the worker's regular pay. So what would happen is the worker would get the benefit at the start of the leave. Connecticut paid leave would pay pursuant to the law, and employers could coordinate the benefits to make up any wage differences. So that would be looking at your short-term disability policy, looking at all other benefits that the employee would be eligible for. Keeping in mind, employees get no more than 100% of regular pay. So just as a footnote, in case it does happen, let's say it's a timing issue where PTO and short-term disability are processed. We don't get the information until a few weeks later. And then we find out, oops, this employee received 130% of their pay. We do have an overpayment process that we have established. So it might take a little while for us, depending on timing of when we receive the information, if there are any overpayments, to identify it, but then we will quickly turn that around and resolve any overpayment issues with direct communication with the employer. So what do your workers need to know? Your workers will be coming to you with questions. So what you'll need to know as part of the Connecticut Paid Leave Program is what kind of benefits do you permit your employees to be paid while they're out on leave? Is it a 5-day PTO? Is it a 10-day? Is it short-term disability day one? These are things that you'll need to consider and to look at prior to administering the Connecticut paid leave. Are there any rules about the use of such time? These all depend on the policies and procedures established by the employer. Do you offer a short-term disability policy? So I would recommend highly that if you do offer a short-term disability policy, you review the policy, and does the policy say that the worker must exhaust other employer-provided PTO before accessing the short-term disability benefits? Some short-term disability policies are written where if there is a state, which this is Connecticut paid leave, so that's a state leave program. Sometimes state leave programs have to be utilized first before short-term disability kicks in. So you'll need to take a look at your policy, at your plan document, to determine how does your short-term disability policy work in coordination with Connecticut paid leave. Sometimes short-term disability policies reduces the amount it pays for Connecticut if Connecticut paid leave, or say a paid leave program is available. So you'll need to look in what I call the fine print to see how is your disability, short-term disability policy written. Okay, now we're going to talk briefly about Connecticut FMLA. Just as a footnote, Connecticut FMLA is different than Connecticut paid leave. And what we're doing is, I believe Jessica had mentioned this earlier, we provide information as a service to employers on Connecticut Family Leave, CTFMLA. However, it's the Department of Labor that is responsible for administering this program. So the worker, again, has to go to the employer, notifies the employer they need to go out on leave, and they need to submit the information in a timely fashion. Provides the employer with supporting documentation, complies with employer attendance and call-in policies. One thing that I have mentioned to employers, if you do not have documented attendance and call-in policies or an established leave policy, I highly recommend that you develop one soon so that there's consistency across the line in administration of all federal FMLA, Connecticut FMLA, and Connecticut paid leave. If you have an FMLA poster, post it throughout your organization. If possible, I know with COVID, a lot of people are working remote, so that may or may not be possible now. But if possible, I would recommend posting it. Process leave requests, monitor leave usage, manage worker return to work. So basically, the monitoring and tracking of hours while someone is out on leave, that all falls on the employer. Connecticut Paid Leave Authority, no official responsibilities relating to Connecticut FMLA, but we do provide information as part of Connecticut paid leave training. Connecticut Department of Labor is responsible for Connecticut FMLA. They provide guidance to workers and employers about CTFMLA. Also, any complaints, denials, issues with claims for CTFMLA would go to the Connecticut Department of Labor. And we do later on in the slides provide the email address to contact the Department of Labor. Even though it is on their website, sometimes it's difficult to navigate, so we have that at the end of the slides. So a worker notifies the employer they need to take time off from work. The worker is not required to use the term FMLA. Sometimes people will come into your office and say, I need to take time off. They don't want to use family medical leave, but that's basically, you know, if they're going out for surgery or taking time off for, you know, medical illness or whatever leave type, that's basically what they're doing. The worker needs to give 30 days advance notice, and as soon as possible if the leave is not foreseeable. So as soon as possible, like if someone has an emergency, God forbid, say they have an accident, a car accident, and then they find out they're able to call, or a family member is able to call a few days later, you're in a situation where you're going to be doing some retro back, you know, pay and adjust all the records and those kind of fun things. So the employer determines if the worker is eligible for Connecticut FMLA and notifies the worker if they need to provide any additional documents. The employer has 5 business days to notify the worker of eligibility and provide what's called a notice of rights and responsibilities. This is not the leave approval. This is just the responsibility for the employer. So the worker provides the required documentation, which is a medical certification from a healthcare provider, adoption documents, military records, whatever is required for the particular leave that the employee or worker is taking. They have 15 calendar days to provide the documentation. And if the worker has difficulty obtaining the documents, they need to let their employer know, and then the employer would give them some additional time. The employer notifies the worker if the leave is approved under Connecticut FMLA, and the employer has 5 business days once it receives the documentation to support the leave request. Employer must notify the worker if they're required to use paid leave accruals, which is the PTO, how the worker needs to report in, who they need to report into, and if the worker will need to provide a fitness for duty before returning to work. So the worker reports to the employer when the worker actually takes leave. The employer tracks the leave usage to ensure that the worker does not exceed the 12 weeks. Sometimes it's the immediate supervisor, sometimes it's HR if there is an HR department, but the utilization of someone being out on leave needs to be tracked. Sometimes that could be done through the payroll system, sometimes through Excel, whatever method the employer decides to use. There is no standard, but when an employee is out of work, it needs to be tracked. So the employer returns the worker to the job the worker held before the leave. The worker has the right to the same job with the same terms and conditions. Employer cannot insist that the employee be 100% fit for duty or totally recovered. And the employer has to consider the American with Disabilities Act and the Connecticut Fair Employment Practices Act and the obligations under those two. Complicating factors for managing FMLA. Managing worker absences, some of the challenges are enforcing attendance and call-in policies, getting timely notice from workers or supervisors about absences, managing intermittent leave due to often unforeseen circumstances. Let's say you have an employee out on intermittent leave, they're approved, and they have a condition where they're going to tell you, okay, at 10 o'clock, I don't feel well due to whatever, I need to go home or I need to leave work. So that becomes a little challenging for employers when there are business needs and then there's a person on intermittent leave. It's just balancing, the workflow and everything surrounding that. Calculating the average work week for workers who work fluctuating work weeks. This is also challenging. You might have on record, this person is approved for, say, 20 hours a week of FMLA or intermittent leave, and then you find out they took 10 or they took 35. So those things should not be happening because, depending on how the leave was approved and what it was approved for. But, people are human and things happen, things don't get documented, they don't get to the employer on time. So it is a little bit, challenging, and it adds a little complication to the administration of leave programs. Sometimes there's insufficient medical certifications, and managing the interaction between Connecticut FMLA, federal FMLA, and other laws could be quite challenging. So as an FYI, workers who don't want to be designated as FMLA leave, it's the employer's right and responsibility to designate that time off that qualifies under FMLA leave, even if the worker does not ask for it. Okay, Jessica.
Thank you, Kathy. So we want to
Thanks.
leave you with some additional resources to help you get some more information. So everything you see here is a downloadable resource that you can find on our website. And if you go to our site, ctpaidleave.org, and you go to the For Employers tab and scroll down, you'll see a series of green buttons. And that's where you can find all of this information. It has just been updated so recently, in fact, that we haven't even put the new screenshots into this presentation yet. So everything that you'll find on the website has been freshly updated. There's an employee rights poster The employee rack card, the second item over that you see, can be very useful to give to employees who are coming to you with questions about Connecticut paid leave, how it works, where do they go. There's a guide for employees, there's a guide for employers, a paycheck insert, which you could provide as well, and a human resources and employer toolkit. Kathy had mentioned, and unfortunately I did not get to update it in this deck, but I put in the chat the link for the Department of Labor landing page that has all of the new FMLA information. So that is in the chat, and that's where you can download the FMLA medical certifications, notices for employees, etc. If you have questions, we are here to help. We know this is a new program. We know there are a lot of questions. We don't have a call center, but we do have a contact us center. So if you go to our website and you click on the contact us tab, you can send us your question. If you prefer to speak with someone as opposed to email, just indicate that and we will have one of our customer service reps call you back within 2 business days. We also have several hundred frequently asked questions on our website, and we have a series of videos as well, some of which are embedded in the website, but I would recommend that you go to our YouTube page. There's a lot of information and videos there, including videos that you can give to employees, which explain to them how to create an account with our online portal, how to submit a claim through our online portal, etc. So with that, we end our presentation. I think we have answered all the questions as we were going through. So thank you again so much for taking the time this morning to talk with us. Please do spend some time looking at our website. We think you'll get a lot of great information there, and certainly reach out if you have any other questions that remain unanswered. Thank you so much, everybody. Thank you, Kathy. Thank you, Amber.
All right. Thank you, everyone. Have a great day.